judges, honorable judges, the court reaffirmed that it is not enough that a remedy exists to satisfy with to the rule of exhaustion of local remedies. So such remedies should be efficient, relevant, and this is, for example, what is shown in the case against Benin, as I said it. So the remedies should be able to remedy to the grievances and have at least a success outcome. If the court has to conclude that such remedies exist or are available, you should see, however, that they cannot remedy to the situation, to this grave situation. On the other hand, this violation go within a context of an illegal situation on the territory of the applicant state. In the communication 220, DRC versus Rwanda and Burundi, the African Commission has admitted the responsibility of the applicant for similar acts that are ongoing today. The African Commission of the Human and People's Rights, through the this communication, has indicated that no investigation was opened and there was no prosecution. In the case ACRWC versus Turkey, the European Court, in paragraph 68, deemed that some specific circumstances can prevent an applicant from exhausting local remedies. And this, for example, the total passivity of national authorities facing very serious allegations, according to which agents of the state have committed errors that have caused a prejudice, for example, when they do not start an investigation, for example, as I have just mentioned. On the contrary, the Respondent State is denying any such a case. For example, in the case against Mauritania, the African Court decided rightly that if there is no prosecution, then the remedy are not efficient. This is what has been demonstrated. On the other hand, the DRC has launched international arrest warrants against people who have committed crimes similar to these ones and who are on the Rwandan territory without obtaining any favorable reaction. Some citizens and nationals are Inosi Orinda, Eric, Jean-Barry, Bundari. These are Congolese citizens who are being prosecuted on Rwanda, and the criminals have not been prosecuted. Also, they didn't offer to prosecute them, and even they did not deport them to Congo. So you have to take into account this political and legal factual situation to judge on this insufficient application or an objection, especially taking into account the Tanzanian case. Allow me, Mr. Vice President, to develop my third argument on the inapplicability of the protection. So Rwanda has founded itself on the exhaustion of local remedy on the basis that the request of the DRC is a diplomatic case. But it changed its mind, and this time it argued that there are some similar cases that will justify this case by analogy, but it is difficult for them to defend it. Why? First, as we said it in our submission, the diplomatic protection doesn't apply in this case because it means that there is a situation where human rights violations have been committed abroad, while in this case the factual facts object of this application happened on the land, the DRC land. Also, all the we have the case of 1998, and its Article 38 confirms what I've just said. Now, regarding the protection of a state in favor of its citizen abroad is also confirmed in cases of reparations of damages, and like, for example, Ethan Switzerland against the United States, and so on and so forth. In addition to the comments of the International Court regarding the diplomatic protection, page 25, paragraph 4. Second, the jurisprudence of the African Commission in the case 240 DRC Rwanda Burundi confirms the irrelevance of the argument about the diplomatic protection which Rwanda tries to establish based on the principles governing the diplomatic protection. In this case, the Commission did not refer to the diplomatic protection, but rather deemed, and I quote, violation object of this case have been perpetrated in the land of the state. 3. The position of the European Court of Human Rights in the case Ukraine and Netherlands against Russia we are referring to should be quoted in their entirety, because this court doesn't discard the possibility to derogate and to waive to the rule of applied in the interstate affairs and matters, and also the possibility to waive from the exhaustion of local remedies in interstate matters when one part denounces an administrative case. According to the European Court, in this case, and I quote, it is the repetition of the acts which have been possible because of the inaction of the authorities which lead to conclude that the local remedies are not enough to prevent that such acts are repeated.
Massive violation committed by the RDF in a repeated manner. In the case cited by the Respondent State, the European Court take into account in paragraph 896 the high number of violations to determine that there is a system in the various acts undertaken, making it possible to establish a pattern. Vice President, judges, I'm going to conclude on why it is not possible to exhaust internal remedies. The African Charter and a protocol establishing the court excludes the application of the rule of exhaustion of local remedies in a situation where the defender is misinterpreting the provisions establishing the court and the relevant provisions of the Charter and the rule. Article 50 of the Charter says the court will examine admissibility of a case brought before in relation to Article 56 of the Charter and 6.2 of the protocol. Article 56.1 of the African Charter provides that the communications in referred to, matters relating to human rights should necessarily fulfill the conditions in Article 55. It provides, before each session, the court will list the that said, a combined reading of Article 56(1) and 55 excludes interstate application. Article 56, the formulation other than those of state parties does not leave any ambiguity, because Article 1 of 56 relate to interstate applications different from those referred to in Article 55, saying that actors other than state party are concerned. Secondly, Rule 40 of the court are not autonomous requirements when it comes to exhaustion of internal remedies, as the Respondent State has said. These rules are autonomous requirements when it comes to exhaustion because they are based on an isolated interpretation of the rule, which constitutes a right without taking into account the primary instruments of the court. Thirdly, and to conclude, the argument advanced by the Respondent State in paragraph 148 in its pleadings, in a case where a commission versus a state, most of the cases brought before the case to justify makes the article devoid of any mission. The practice demonstrates the opposite. Most African states bringing cases before the court or commission, and the African court has received 325 from individuals and 22 from NGOs, and all these lead to the conclusion that the case referred to in 25 is those between individuals and NGOs, individuals or an NGO to a state, because these are the most frequent cases brought before the commission as well as before the court, contrary to the assertions made by the Respondent State. Honorable President, honorable judges, taking all this into account, we invite the court to say that the diplomatic protection does not apply, and also the exhaustion of local remedies does not apply. Thank you for your kind attention, and I invite you to give the floor to Professor Lumumbaya. Honorable Vice President, honorable members of the bench, it is a renewed honor for me to take the floor before your eminent jurisdiction as part of the ongoing proceedings. I'll address the exhaustion of international and regional remedies in order to avoid facing up to its responsibilities of violation of human rights in the DRC. Rwanda has come up with a number of arguments, and in truth, these are pretexts to argue that the present case is inadmissible. They have they have cited a rule in relation to non-exhaustion of international regional remedies. this has been swept aside by my colleague Tresor Moindo, who took the floor before me. So I'll not go back to that. In Rwanda, also made reference to two pretexts. First of all, Rwanda expect to obtain from your court the inadmissibility of the application of the DRC on the grounds that the applicant ought to have and didn't exhaust international and regional remedies available to it. Secondly, that DRC did not respect the preliminary requirements, did not respect the preliminary non-judicial procedures required. I'll methodologically to counter these arguments brought before you. Honorable Vice President, honorable judges, the alleged non-exhaustion of international regional remedies is not a requirement nor a legal obligation for the admissibility of the application of the Democratic Republic of Congo in the instant case. Indeed, let me recall that we are here having before us a confusion orchestrated by the Rwanda relating to the remedies provided for in Article 50 of the Charter and an alleged exhaustion of international regional remedies, which according to them flows from traditional rules as well as diplomatic protection which they brought forward against the arguments of DRC. Rwanda finally admitted that this is not a context of diplomatic protection where the rule of internal exhaustion of internal remedies would apply. My predecessor brought up arguments to show that the limitations of the arguments relating to the exhaustion of local remedies. In an event, probably in a miraculous manner, that this rule will be accepted by the court, Rwanda does not indicate any reference, does not give any reference that will which will serve as a basis in relation to the international regional remedies, and they do not indicate any procedures, any relevant procedures. In Rwanda, therefore, limited itself to a citation of previous practices in relation to the Vienna Convention, the right of treaties, and to conflate it to the exhaustion of international regional remedies in Article 50 of the Charter. Honorable Vice President, honorable judges, the learned professor on the other side said that this is the practice between practices, whereas it was necessary to identify the alleged practice which is applicable, and then we need to verify if the DRC considers this to be an applicable rule, and in any event the DRC objects to this. using this malicious intellectual gymnastic, Rwanda is trying to give a wider scope to this article of the Charter. The African Commission on Human and People's Rights, which is not the same as the rules of this court, pointing out, let me point out, Honorable Vice President, Honorable Judges, to what extent Rwanda is allergic to the Commission when they say things that, when the Commission says things that are not in their interests. Either the problem is that there as well, the reasoning of Rwanda has legal problems. Normally, they talk about the what can be gleaned from the decisions of the Commission. How then can they reject some of the decisions of the same Commission when it does not favor them? Now they come to appeal to your jurisdiction, the application of the rules of court of the same Commission, whereas the court has its own rules of court, which logically should take precedence in our situation for purposes of relevance and accuracy on the issues before us. Honorable Vice President, Honorable Judges, in any event, it is based on their reasoning that Rwanda is claiming that DRC should have attempted negotiations in relation to the alleged conflict or sought the good offices of the UN before coming before you. And they are saying that when you examine the examination of the context of the African Charter, support this conclusion, because all interstate procedures will require a prior dialogue between the states involved in pursuance to Article 44, and give them time of reflection to arrive at a mutually satisfactory solution, which is not absolute. The DRC would like to point out that the internal remedies provided for in Article 50 of the Charter relate only to the framework of diplomatic protection, which unfortunately for the respondent state is not the object of the instant case. We can never overemphasize the fact that the rule of exhaustion of internal remedies, which Rwanda is attached to, does not apply here. It's not relevant here. And in a matter between the two parties before the Commission in 2003, and here, I believe that Rwanda is not going to deride the relevance of this case that I'm citing in support of the rules. It said that when the acts underpinning the alleged violation of human rights occurred on the territory of the applicant state, there's no issue of exhaustion of internal remedies, and that this does not apply. Similarly, as your court has already asserted this in Alibi Igame versus Tanzania, no prior procedure is required in such circumstances. When DRC decided to come before your court, no valid legal reasons requires it to go through any prior procedure before coming before you. Further, Rwanda's attempt to extend the scope of application of Article 55 through the interpretation of Article 102 of the Rules of Court of the Court creates further problems. Apart from being inaccurate in international law, it is not well grounded. First of all, because Rwanda raises this objection before your court on the basis of a rule applicable before the Commission in the rules of that Commission, Rule 109, which is the basis for going before the Commission and not before your court, and looking at things closely in point 2b. The rule provides that the communication should contain information on the following elements to be accompanied. B, measures taken to exhaust regional or international to resolve the matter. Honorable Vice President, your honorable judges, such a provision cannot be relied on before your court, where auxiliary measures of exhaustion of the measures before it, and this is not one of the requirements. Further, given the fact that the court's rules of court in its 2010-2020 versions did not make any such requirement extending the Article 50 of the Charter, there's then nothing to make such a suggestion. According to Rwanda, the absence of the requirements of Article 50 of the Charter suggests that the remedies to be exhausted will also include international regional remedies. Rwanda is also trying to mislead the court in relation to Rule 109B of the Rules of the Court, which makes specific reference to regional or international remedies and not remedies in general. As they claim, and wrongly so, such a manipulation cannot be tolerated by your court and should be dismissed with all the consequences that flow from it for Rwanda. Given the fact that this is not a conflict in the classical term of the sense, there's no reason for the Democratic Republic of Congo to have recourse to the said international regional remedies that Rwanda is making reference to Article 46, 47 by conflating it with other requirements. DRC would like to clarify that the procedures provided for in Article 47, 48 of the Charter are the basis of measures to be exercised, and they provide as follows. If a state signatory to the Charter violates the provisions, it could, through a written communication, draw the attention of the state to the attention. This is Article 47. If within a period of 3 months from the date of reception of the original communication, the issue is not resolved to the satisfaction of the two states involved through negotiation, bilateral procedures, one or the other will be entitled to submit the matter to the Commission through a communication addressed to a corresponding address to its president and to other instances of the African Union. That is Article 56. DRC points out that Rwanda deliberately avoid mentioning Article 49, which specifies clearly that notwithstanding the provisions of Article 47, if a state party to this party and another state also party to it may directly address a communication to its president, Secretary General of the AU, and to the state involved. All these provisions of the Charter establish the establishment of a truth, that is the latitude or the possibility to negotiate, which is a possibility given to all states party to the Charter. If they find it necessary, it is neither an obligation nor a precondition to be satisfied before coming before your court. As the court may observe, Article 48 is permissive and not mandatory. We agree with our colleagues on the other side. Just as they can come directly before the court, in one or the other case, the Article 48, provisions of Article 48 will have to be respected. DRC has decided to come directly before the court because it believes that Rwanda has violated and continues to violate human rights protected by the Charter and other relevant instruments in relation to human rights. How then can we imagine that while on the field human rights are being violated, human rights are being overlooked, entire ethnic groups are targeted by military groups? How then do we start with negotiations with a state that has genocidal intentions? Article 49 of the Charter, overlooked by Rwanda, makes mention to this possibility granted to DRC. The court will observe that Rwanda does not counter the arguments of DRC on this permissive and non-mandatory of Article 47 of the Charter. It would be improper to interpret the Charter not in its totality but based on specific provisions. Honorable Vice President, honorable judges, with your indulgence, I would like to move on to my next argument. As a precondition, among these preliminary procedures, Rwanda claims that Rwanda did not exhaust procedures enabling it to resolve the conflict through investigation, and that it ought to have followed the mandatory preliminary procedure prescribed by the African Union. Rwanda claims that the matter is based on political issues of peace and security, which is wrong, and claims that the RC should have gone through these preconditions. The obligation to respect the procedural measures provided in Articles 28-29 of the Great Lake Pact cannot be applied to this case. The procedure prescribed in those provisions do not really apply to the African Court, which is a specialized court on human rights, as we said yesterday. It relates to the general mechanisms, general justice mechanisms within the African Union. So that procedure is applicable when there is a conflict requiring the interpretation and application of the Charter. Rwanda went as far as claiming that human rights violations for which there's perfect reasons to believe that they are the authors are political issues relating to security, and that there is nothing relating to human rights violations. And then they go on to suggest a procedure provided for in Article 29 of the Pact. Given the applicable laws, it looks like they want to constitute an obstacle to the work of the court. They have the vain attempt to characterize their activities differently is to divert the jurisdiction of the court. Let's assume that DRC failed to comply with the preliminary procedures. Rwanda recognizes that the court they are referring to is not a court of the African Union, and this court will therefore does not have to respect the requirements of another court. We are here before a confusion which is in the imagination of Rwanda when they need to overlook the truth. And this is due to a misunderstanding of the African Union Charter. The court will therefore not show any indulgence to those who, out of bad faith, are trying to. It will be wrong for them to bring this argument before this court. DRC therefore invites the court to dismiss this argument. It is on. It is here. I like to conclude my submissions, Honorable Vice President, Honorable Judges, and I thank you for your kind attention and request you to give the floor to Lawyer Jean-Paul Mwanza to continue with the plea of the Democratic Republic of Congo.
Honorable Vice President, Honorable Justices, I would like to thank you for giving me the floor to continue the plea of the DRC as regards the compatibility of the submission with the Constitutive Act of the African Union and the origin of the sources mobilized by the DRC to support its application. Rwanda has talked about a number of legal provisions that all refer to Article 56 of the African Charter in order to reboot the the admissibility of this application, which are not founded and not grounded, as I will explain it later on. Rwanda seems to ignore that this article excludes explicitly the interstate applications, insofar as that any other application or applications or rules referring to this article in matter should be considered as non-admissible when it comes to such applications. It is Article 6 of the Protocol of establishing this court and Rule 50 of the rule which Rwanda refers to. You would see that Rwanda is using confused arguments, and they are inconsistent in developing their arguments. The pleading of Evongil Machar has underlined this confusion in the reasoning of Rwanda. I would like to start to explain such means used by Rwanda especially the incompatibility of with the Charter and the African Union Constitutive Act, and I'll come back to the argument used regarding to the origin of the sources mobilized by the DRC to support its application. Honorable Vice President, Honorable Justices, I would start with the first point relating to the so-called incompatibility of the application with the Constitutive Act of the African Union and the African Charter of the Human and People's Rights. Rwanda alleges that grave and massive violation of human rights perpetrated and that they continue to perpetrate in Congo would constitute issues of peace and security, and therefore political issues that should not be examined by this court. The representatives have mentioned it yesterday and today too during their submissions. Allow me to indicate that by raising such an objection, Rwanda is making a confusion between the issues of jurisdiction and the admissibility. The argument used by Rwanda consists in saying that the application of the DRC should be considered by the African Union, not by this court. The arguments are artificial insofar as Rwanda has not demonstrated with accuracy what violation human rights invoked by the DRC would constitute political issues that will relate to the relevant organs of the African Union, that is to say the conference, and the Peace and Security Council of the African Union. Rwanda forgets that the notion of peace and security has been determined, should be determined in its substance and form. They have not indicated their legal meaning, and to what extent the violation of the human rights invoked by the DRC would be part of issues under this purview, which make us doubt on the credibility of the argument used. Mr. Honorable Vice President, Honorable Judges, how the violation of the right to life and physical integrity invoked by the DRC in its application could constitute reasonably an issue of political or peace and security issue, and therefore escape to your consideration. On the other hand, the debate on the legal nature and political nature of the issues submitted to the consideration of international jurisdiction has become today not relevant. They have only a historical value. But if you have to come back to them to justify this code, the DRC would like to underline that the international jurisdiction admits that legal issues are the ones that pose issues of law, and for which a jurisdiction is called to make interpretation and implement the principle of legal rules. This is an extract from the International Court of Justice in the case of Western Sahara, para 15. Based on these references, the International Court of Justice has estimated that the court cannot not answer to legal elements for a question, whatever be the political aspects, to undertake a judicial mission, that is to say the appreciation of this case under the international law. This is put under the paragraph about the conformity with international law, and the case relating to Kosovo, paragraph 27. Moreover, Rwanda has visibly a very limited conception of peace and security. They forget that to date there is a relationship between peace and security and human rights violation. The position they defend in this prospect suggests that any application on violation of human rights committed in an armed conflict context, such as the one waged by Rwanda in the DRC, should be declared inadmissible. At the same time, and paradoxically, by responding yesterday to a question of one of the honorable judges on this issue, the lead counsel of Rwanda answered that the dimension of human rights is not included in this case, but that the case would relate not only not exclusively, but essentially on political issues. Semantically, if we situate these words semantically, we have nevertheless to draw the legal meaning of such words. However, the danger of the argument of Rwanda, if the court declares the admissibility, the court will be deprived of its competence based on the violation of human rights, since there is a relationship between peace and with them and peace and security, which will deprive your court from its relevance in this context of the African continent, which knows grave violation of human rights, such as the ones perpetrated on the Congolese territory. Mr. Vice President, after this contextual arguments, I would like now to talk about the relationship with the African Union Charter, especially regarding the jurisprudence of this court. Regarding the case Abubakar versus Tanzania, it concluded that what is important for a case to be compatible with the Constitution of the African Union and the Charter is that in their substance regarding the violation, they should be able to be considered in reference to provisions of the Constitutive Act or the Charter, and should not come manifestly outside the scope of these articles. It is under paragraph 50. The respondent state cannot contest the fact that the case submitted, which is or rather talks about grievances that deal with the grave and massive violation of human rights perpetrated by Rwanda on the Congolese territory, and that the applicant state is requesting your court to consider them in reference or in conformity to the provisions of the Charter and other relevant texts. On the other hand, your court admits that a case is compatible when it enables to accomplish the objective of the African Union texts. So, in conformity with the Constitutive Act, the objective is to protect human rights as guaranteed by the Charter. That is why it has concluded in the matter Chacha versus Tanzania that the application is compatible with the Constitutive Act and the Charter when it is compliant with the objective of the African Union, and when the court has to determine whether yes or no the human rights are guaranteed by the respondent state, and this is included in paragraph 124 of this judgment. And in the case Alex Toma versus Tanzania, the objective of the African Union is to promote and protect human rights and people's rights in Africa. This protection should go through the strengthening of the mechanism relating to this objective. Also, it has to go to get along with the adoption of appropriate measures to guarantee the respect of human rights. Therefore, the DRC is requesting the court to indicate that Rwanda has perpetrated human rights violation, and that it will take measures in implementation of the international law. The compatibility in this at this level is not enough. Like in Alex Toma case, you have just to say that there are facts relating to human rights violation protected by the Charter, and this is in paragraph 56 of this Charter. The prima facie appears when it was concluded that the application should show a prima facie violation of human rights as protected by the Charter. The court would note indeed that the application of the DRC fulfills all these requirements, legal requirements. So as indicated yesterday by Professor Tumbalumba, there is no doubt regarding the legal fulfillment of all the requirements and also the violation of Rwanda of human rights. Honorable Vice President, Honorable Justices, now I am going to tackle the last item, which is the origin of the sources mobilized by the DRC. I will tackle it under two angles, and I would like to mention the contradictions in the pleadings of Rwanda, and also by restituting the scope of the requirements of the origin of the sources in order to show that the application of the DRC is not exclusively based on mass media communication only. In its inadmissibility objection, Rwanda says that we are basing ourselves on mass media articles, while they say that a careful scrutiny can be used as evidence of allegation of human rights violation in the region. Indeed, Rwanda is entertaining deliberately a confusion between issues of exclusivity of the origin of the sources coming from mass media, which relate to the admissibility of the application, and that relating to the production of evidence to support an application that should be analyzed as regards its form, its merit, and at this stage it is not useful to mention the issue of evidence regarding to human rights violation. The analysis of the jurisprudence of the court shows that this requirement aims not the quality of the sources, which means the consideration of the evidence, but rather to the mass media nature. So, in fact, they want to forbid the spreading of information through the mass media. So, but it does not prevent from the possibility to mobilize such information with the means coming from other sources. In other words, Honorable Vice President, this requirement is not founded on exclusion criteria, but rather exclusivity of information drawn from mass communication means. The African Commission has admitted this interpretation. It's Communication 141 and the number 149 in the case Dauda Diawara versus Gambia, when it asserts, I quote, while it is not relevant to rely only on mass media communication, it is not advisable to dismiss a communication because some aspects are based on information disseminated by mass communication. And this comes from the fact that the Charter is using the expression exclusively. It has also indicated, and I quote, that no doubt that mass media communication remain the most important source of information. We all know that information on human rights comes also from communication, mass media communication. And what is even more interesting is that the Commission indicates and talks about the genocide and says that genocide in Rwanda has been disseminated by mass media communication. So the question here is to know how Rwanda, which allegation of genocide were founded on news disseminated by communication means, will dismiss accusation of human rights violation on the Congolese territory because they are based on such sources. And this is an additional evidence of the pragmatic self-destruction of the arguments as mentioned yesterday by the agents of the DRC before your court. At any rate, the DRC has produced some elements that show that it doesn't rely only on communication communicated by mass media. the elements mobilized by the DRC do not come exclusively from such sources, but rather they're trying to extend the scope of this requirement, saying that it should not be interpreted by referring only to articles, press articles, but rather it should include information based on these sources. Honorable President, honorable judges, it seems that the real objective of Rwanda is to question and challenge, as usual, the relevance and the credibility of some official sources, such as the one of the United Nations, the African Union, and NGOs that show its responsibility in the violation of human rights perpetrated in the DRC. In Rwanda, even they talk about the military captured in the battlefield in the Congolese territory, referred to yesterday by the professor, and the presence of its defense forces, which are now in Goma and Vigo, denounced by the RC and disseminated by the media, that constitute, in fact, a violation to peace, have been not been shared to the should not be shared to this court because they come from mass media information. As I said it before, the appreciation of the quality and the relevance of the elements of proof and evidence from the DRC should be done in the preliminary consideration of the merits of this case, and now we should really concentrate on the preliminary objections. So the DRC respectfully praise this court to dismiss the objections of Rwanda on these two issues. Honorable Vice President, honorable justices, I thank you for your attention, and respectfully I would like to give the floor to Professor Zeki Ceremony, who is going to continue answering to the DRC regarding the objections.
Honorable Vice President, honorable judges, I thank you for giving me the floor, and it's a great honor for me taking the floor before you for the first time for DRC. I'm going to respond to Rwanda's argument, arguing for the rejection, non-admission of the application. Rwanda is saying that the facts cover issues that have already been resolved, in which case the case would have violated the non-bis idem and res judicat principles. Rwanda is extending these principles to pending matters. In the case of litis pendant, which indicates general principles of law. Before I indicate that Rwanda's interpretation of these principles have no legal basis, first of all, I'd like to give my own interpretation. First of all, in its application of 15 December, Rwanda, in paragraph 19, indicates that it will establish that the same matter had been already determined by the East African Commission in its preliminary objections. It made reference to this argument. It then, or Rwanda, then claimed that there's another decision that has determined the current matter. Once again, in paragraph 39, they indicate, and I quote, the Respondent State, that the East African Court of Justice has not yet determined this matter, and this has been confirmed in the pleadings. as they normally do, they change position. They no longer support the argue that the application does not comply with Article 50, Rule 50, because there's no matter. And to justify the violation of this rule, Rwanda is currently putting forward another argument to the effect that this matter, according to them, is likely to be resolved before the court has the possibility to determine the case. That is in 138, paragraph 138, and also confirmed in their submissions. Honorable Vice President, honorable judges, this is a simple demonstration that the Respondent State's argument in relation to non-bis idem and res judicata is not justified here, because there is no previous decision. And this is why Rwanda is now trying to extend the application of Article 50, paragraph B of the rules relating to pending cases to specific case of respondent. And here, and I'm going to focus on this as I go forward, I'll demonstrate that the extension of Rule 50 of the Rules of Court to cover pending matters, that is, matters that have not yet been determined on the merits, is without a legal basis. Further, and I will demonstrate that litispendant, which has been referred to by Rwanda, is not applicable here. My last point will demonstrate that the extension of the scope of Rule 50 to lispendant has no legal basis. Rwanda argued that this rule covers a situation in which the same dispute is brought before a court. There are cases in which litispendant, this reading is wrong. Your court has always indicated in Bernard Morin cases versus Burkina Faso, and I quote, a matter is considered determined within the meaning of Article 50 if three cumulative conditions are identified. First, identity of the parties is the same. Two, the matter to be determined are identical or essentially similar to those brought before the court. And three, the existence of a first decision. You said that in 22nd September, your court, on the same occasion and in the same paragraph, underscored, and I quote, there should be a definitive settlement of the matter. That is the very substance of Rule 52 of the Rules of Court, interpreted differently by extending its scope to matters that are not yet determined, as Rwanda is trying to do, will be to deprive this rule of its meaning. Honorable Vice President, honorable judges, let me move on to the second point, and that is on the non-applicability of litispendance in the instant matter. The procedures of your court does not resolve the matter of litispendant between your court and another court, apart from the specific case of the African Commission. From 140 of Rwanda's pleadings, litispendance in the For Rwanda, and I quote, these principles regulates before other instances before other regional instances on human rights and applies to the court as well. We therefore need to demonstrate that given the current state of international procedural law, litis pendente as a general principle of law, as Rwanda is claiming, is very controversial. But let us assume that that is the case. The conditions of its application are not met in the instant case. Honorable President, honorable judges, let me now demonstrate that litis pendente as general principle of law, it's controversial in international procedural law, and I underscore the fact that this is an argument that Rwanda has advanced by Rwanda. The doctrinal sources and jurisprudential that Rwanda is citing in relation to do not support their position on litis pendente. To assert that litis pendente is general principle of law, Rwanda is relying on the work and doctrine, particularly positions of authors like Filipiani and August Piani. In a work of res judicata litis pendente, beyond the fact that this is an isolated doctrine, it's also very controversial. First of all, the two authors that Rwanda is referring to have agreed that their position is challenged in page 258, and I quote, that many authors have criticized the position of these authors. For example, Luis Edgardo Salles, in his work Forum Choice and Forum Shopping, he says as follows, and I quote, in fact, the dominant doctrine on litis pendente is not based on international law, nor customary law, nor even as a general principle of law. Whatever the case, the doctrine is an auxiliary manner of determination of rules of law, including general principles of international law. And in that case, if the doctrine helps to determine the existence and content of that rule, it does not clarify it. Rwanda also tried to mobilize the rules of European International Court, but the manner in which they rely on this case, that to make reference to litis pendente and apply it to an interstate case like this one, is totally wrong. The matter decides on systematic violation of human rights carried out by separatists or terrorist forces. In that matter, Russia argued that the matter is exactly the same as Georgia versus Russia Confederation, which was before the court, without examining if the two procedures were on the same manner. The European Court on Human Rights, in paragraph 59 of its judgment, the court notes that in decision of 2011, the ICJ said that it is not competent to deal with the matter before it. The procedure before international international court is therefore closed. Further, Article 55 of the of the European Convention applies only to individual applications. Your court should therefore totally dismiss the position of the respondent state. This doctrine has never been confirmed by international courts, including the the European Court of Justice, that the respondent state is citing. Honorable Vice President, honorable judges, in any event, this is my second sub-item. There is no situation of litis pendente between your court and the East African Court of Justice. On the one hand, your court and the East African Court of Justice are not jurisdictions of the same order, and they do not exercise concurrent jurisdictions. And if there is a cumulative treaty in relation to that which has not entered into force. So now let me demonstrate that your court and the East African Court of Justice are not courts of the same order and do not exercise concurrent jurisdictions. And this is how I'm going to answer the question that Honorable Justice Ajay put to us yesterday. For the doctrine of litis pendente to apply, the court needs to ensure that the jurisdiction before which the case are brought are jurisdictions of the same order. That is what was asserted by the Permanent Court of International Justice in a matter of relating to some German interests, where they said, in rejecting the Cologne application, the International Court of Justice declared that the parties were not the same, that the acts were not the same, and also the tribunal are not courts of the same order. Similarly, I need to clarify that your court and the East African Court of Justice are not the same. The treaty that established the East African Court does not give it that status. In Article 27 is unambiguous, and it provides, I quote, the court should first be competent for the interpretation and application of the treaty, subject to the competence of interpretation conferred, or the court does not involve the interpretation of given to instances of other courts. Paragraph 2, the other jurisdictions when it comes to appeal on human rights, command, and so on and so forth, are decided at a subsequent date. The member states therefore have to determine the jurisdiction of these instances. The obvious implication from these provisions is that your court needs to take note of the fact that the protocol envisaged in paragraph of Article 7 has not yet been adopted. That makes untenable the position that the East African Court of Justice is a court of the same order, at least from this standpoint. Further, if some provisions of the East African Community Treaty, particularly Article 6.2, 7 paragraph 2 on objectives of the committee, promotion and protection of human and people's rights, in conformity with provisions of the African Charter, the two can nonetheless not be considered as same. The jurisprudence of the court, of the East African Community Court, which interprets the two provisions, and in that matter, James Katabazi, which has become very famous, which was cited by Rwanda, the court asserted in one paragraph that Rwanda omitted to read, and that is on page 16 of the judgment, and I quote, this assertion has entered into the jurisprudence of the court, and the conclusion, the inevitable conclusion here is that since the East African Court of Justice and your court are not jurisdictions of the same order and do not exercise concurrent jurisdictions, because the East African Community Court itself said that we shall not assume jurisdiction in human rights, but that will not prevent us from examining the respect of member states to the respect of human states of the Charter, even if it involves human rights. Honorable judges, in the unlikely event that your court will conclude that it is the same order as the East African Court, the truth that the three cumulated conditions are not met. Litipendency applies in parallel procedures, identical person, identical facts, and when those two matters are before two different jurisdictions. This means that all these elements should be present, and that it is not enough to talk about one separate from the other. But Rwanda, there's no similarity between this court and the court before the East African Court. Secondly, there's no identity of action in the two cases. Let me now demonstrate that the cases do not have the same object. Rwanda argued that the two procedures involve the same legal argument and the same remedies. They are basing themselves on similarity of the facts, similarity of the allegations, and similarity of evidence and the prayers. First of all, the similarity of the facts is not and should not be included in the criteria. It is not done normally. Now, the legal issues raised are dealt with, are set out in paragraph 25. Paragraph 26 specifically sets out the details of the violation of the East African Treaty. These two paragraphs describe how the factual matrix violates specifically the Charter of the East African Community. And since your court, for your court, the violation, these violations have nothing to do with violation of the African Charter. Article 6.2 of the East African Community Charter and Article 7 makes reference only to the Banjul Charter. And finally, and this is my third reason, the case brought before you is not identical to convince yourselves. Please refer to paragraph 29 Honorable Vice President, Honorable Judges, measures or the prayers here, which I will not read again, are specifically related to the East African Court of Justice and cannot apply to your court. Your court cannot order such measures. And now let me demonstrate that the two parallel cases are not based on the same causes. The East African Court of Justice, in its judgment, Peter Ananyongo in 2007, and in its paragraph 15, obvious. The simple presence of similarity of factual matrix does not mean that the cases are the same to activate the least pendant. The case before the East African Court is based on the Treaty of the East African Community and is similar for the factual matrix. In the instant case, it is specifically related to the violation of the African Charter and other relevant instruments on human rights. Finally, the applicant prays your court to take two decisions: that the objection based on paragraph 50 of the rules of court is baseless, and it's on that basis that, Honorable Vice President, Honorable Judges, that I would like to thank you for your kind attention, and I pray your court to give the floor to my colleague, Professor Minashan, who will demonstrate, following my submissions, that this objection to admissibility, that our position is not an abuse of procedure, of process.
President, Honorable Justices, I would like to thank you once again for giving me the floor. My intervention will be the last one regarding the substantial aspects of this stage of procedure in the continuity of the pleadings of my colleagues. I will challenge the argument of Rwanda on the admissibility of this case, as it is abusive process before this court. I would like to reaffirm that we are not pleading on the merits, but rather, like my colleagues, I will try to underline some factual factors in order to show the logics of our reasoning. As you can see, Rwanda would have tried everything, yes, everything, to put an obstacle to the smooth running of a trial against activities perpetrated on Congolese territory. Allow me to note at this stage, in order to set the stage, to recall that my country is paying the tribute of African solidarity by accepting to welcome Rwandan refugees in 1994, but even before. For example, Honorable President, the genocide against Tutsi in Rwanda ended to 800,000 victims, and now Congo counts 13 million victims and massacres due to heinous activities, actions and acts perpetrated by Rwanda on its territory. And also they try to divide factions and they try to perpetrate the genocide, which had led to massive killings, rapes, incineration, calcination, and other barbarous activities. Mr. President, I remember that one of the what we have seen during the criminals of war was based on a film that showed the acts, barbarous acts, and some people even could not continue watching these films and video which were displayed during this court, in order not to see the reality which was shown by these videos. So they lacked courage, and even till today they even killed themselves and committed suicide because of what have seen. This is the same thing in Rwanda. So they are afraid of this trial because they are going to see the images, the skeletons, the manslaughter, images of rapes, children killed, and mothers assassinated in front of fathers who are being tortured. So all these acts against Congolese population, and even the difference between the genocide of in Rwanda and genocide against Congo is that the first is an ethnical genocide. The American Secretary, dear, we are now pleading about the objection to admissibility. So let's continue to focus on that. This is to tell you that the fact is that your court is not lacking jurisdiction. In fact, Rwanda is afraid to be submitted to a trial at the end of the day, because all the arguments submitted by the DRC show that its application meet all the conditions of admissibility after showing the jurisdiction of your court. Regarding the last pretense regarding the abuse of process, in fact, there is no cumulation of similar cases, and Rwanda is trying to even refer this case to another jurisdiction. There is no abuse of procedure when this procedure is provided for by an applicable text of the court. My colleague before me has demonstrated that nor the general principle of the judicata and the pending case should not apply to this case. Also, the exceptions and the objections raised by Rwanda show that these we cannot assimilate this action to an abuse of process. this court has deemed, especially under paragraph 44 of its order of 22nd November 2022 in the case against Benin, that a application is abusive if it will show that an applicant was filed it not in good faith and in contrary to the judicial practice. Rwanda pretends that the exercise of parallel procedures between two international courts on the same question would constitute a circumstance for abuse of process, paragraph 159 of its pleadings and submissions. I don't see where we should challenge a state that has is the competent court if saying that it is an abuse of process if this case is submitted on good grounds. So a similar argument was invoked on several occasions before the International Court of Justice. The councils of Rwanda cannot pretend to ignore that constantly allegations of this type have always been dismissed. For example, in the Terafostat Anuvu case, it was demonstrated that there was no good faith in this case, and I quote, in the exercise of its discretionary power, the court should dismiss such cases and similar cases. But the court has considered that the application of Enuvu was presented in an appropriate way based on the remedies it has at its disposal, and it is enough for it to note that such behavior is not an abuse of procedure or process. Similarly, in the case of immunity, France and Equatorial Guinea, that there is a process, an abuse of process, because it was introduced in the absence of all remedies, and the court has dismissed this case. The court deemed, and here I quote, that Equatorial Guinea, that has established a valid competence basis, that it should not see its application dismissed if there is no element showing that its behavior is based on a abuse of process. Some exceptional circumstances can dismiss a request, an application based on valid grounds. Yesterday, we have underlined the problematic behavior of Rwanda vis-à-vis the African Commission of Human and People's Rights, and this is an additional evidence. Rwanda is inviting this court to refer to the ACRWC, and this is Article 124, and Rwanda affirms that the Commission has declared the case inadmissible in a given case because it was submitted to a different court. As I said it yesterday, the problem is the interpretation made by Rwanda, which is not accurate. Similarly, Rwanda tries to mobilize the inter-right case against Ethiopia this morning, but this case is not relevant insofar as the facts and the nature of the commission, of the Ethiopian Commission, cannot be compared or transposed to this case to justify the inadmissibility decision for abuse of process grounds. The learning we can draw is that when an applicant submits an application to a court in conformity with legal grounds, the court cannot conclude to abuse of process unless there is an evidence of the existence of exceptional circumstances demonstrating a bad faith of the applicant, and Rwanda did not demonstrate it. And this procedure could be a waste of resources. The International Court of Justice, in its practice, have never seen or identified such exceptional circumstances, even if the exception to abuse of process is invoked progressivly and more before this court. It has always rejected such grounds. The European Court of Human Rights in similar cases has often deemed that the intention of the interested party to mislead the other party and also the court should be based on demonstrated, which Rwanda could not demonstrate here. Honorable President, honorable judges, my last point, it will be a question. Is there an obligation, a legal obligation, for the DRC to communicate to Rwanda information relating to an application which is not yet submitted to another body? The opposing party has noted from paragraph 153 of its rejoinder, has tried to show some insufficiencies because the DRC has not provided information to the East African Community Court of Justice. However, Rwanda avoided to precise a basic element of the problematics, that is to say, when the effect of Rule 41.3c of the rule should be used and deployed. The answer to this question is edifying, since Rwanda recognizes explicitly under paragraph 155 of its rejoinder that the application was filed in August 2023, the additional application on 2003, and to the East African in September, and the modified act was submitted on 25th September 2023. In other words, when you follow such a chronological order, you can see that when the application was submitted to this court, we could not expect from the Rwanda to meet the requirement of Rule 41.3c by providing information on a procedure which was not existing. So this should be an abuse of process. In other words, the contextual interpretation of Rule 41, which refers to the substance of a rule regarding to disputes, show clearly that it is when the application is filed that the divulgation or the communication requirement should be met, while there was a case introduced in the EACG, and Rwanda tried to extend the scope of this rule to the existence of a so-called intention to refer to another mechanism. This is what appears from its rejoinder. Another question: Rwanda, could it tell us to which extent they can go to implement Rule 41.3c of the regulation? This rule does not impose that we add information on mechanism of international courts. We intend to refer to in the years, the months, the days, the weeks which are coming. They are about information that exists on mechanism which have been referred to when this application was filed. So this can lead to a non-seizure decision, and this can also lead to the effective seizure. And I would like to add, Honorable Vice President and Honorable Judges, that in the line of what I've said, the applicant prays the court to decide on the inadmissibility, and it is not grounded. This being said, the DRC would like to summarize all this argument, and it has indeed tried to challenge all the allegations from Rwanda and to demonstrate that the opposing party submission are not consistent. Honorable Vice President, honorable judges, the DRC is convinced that you are going to rebut Rwanda from all this, what they are submitting, their submissions, and you are going to issue a decision for the promotion of the human rights on the African continent. Thank you for your attention.
The applicant state, you still have 5 minutes. Very well. We'll adjourn and come back in an hour's time.
I just wanted you to make a comment on what I'm going to say, just briefly. Here where we are, it's a human rights court with its own procedures and instruments. I could say we are self-contained. And from your submissions, I heard you are encouraging the court to look elsewhere to the procedures of other courts. And I've said we are self-contained. Is it really necessary? During submissions, I heard Dr. Owiso say that the claim is in respect of people's rights and not states' rights, whatever that means. I also had Counsel Aboje, hope I got it right, saying that these are violations of rights of nationals of DRC by Rwanda that form the subject matter of this application. How do you reconcile those statements with the position which you took during the submissions, that this is a matter purely on security, peace, sovereignty, and territorial integrity, and not necessarily human rights? I would just want to hear a comment from you on that one as well. A direct one, a more direct one? Is the case which you referred to that was lodged with the East African Court of Justice between the parties, is it a bar to this one? You referred to so many principles there. Res judicata was discussed. I had known this in idem, lis pendens, and so on. Then I also had Counsel Aboje saying that it could be considered as a local remedy to be exhausted before coming here. So is it a bar? Finally, and I really want you to understand me on this one, I'm glad this is an African court and it's Africans that are here litigating. When you see a frog jumping around under some scorching sun and the ground is hot, then you must know that wherever it's coming from, things may not be very good. You've come around looking for justice. By the time you came here, things must have not been good out there. And there are many ways through which we can give you justice here. The respondents especially referred to those other mechanisms in the Constitutive Act, plus the Great Lakes Pact of Amicable Settlements, and so on. I would like to draw your attention to Rule 64, Sub-Rule 2 of this court. And would want to know, what is your comment? What would be your comment on the provisions of Rule 64, Sub-Rule 2? Thank you, Mr. President.
Merci, honorable juge. À présent, honorable juge Adjé, vous avez la parole pour vos questions, s'il vous plaît.
To be centered on exhaustion of local remedies. I've gone through the Rwandan Constitution, and Chapter 4, that is from Articles 12 to 43, they are on personal rights. That is, only persons can exhaust, invoke and exhaust. Why do you expect Republic of Congo to go and make attempt to exhaust personal rights when they are personal to those who have suffered? Because they are not rights available to a country to exhaust within your own jurisdiction, because your own Articles 12 to 43, that is what they say. It is a personal right. So why do you expect a country to go there when you know that it cannot be exhausted? That is the first one. And the second one is that you referred to several European cases, but all the European cases, particularly Georgia versus Russia, I'm going slowly, Georgia versus Russia, 2011, European Court on Human Rights, application number 13255/07. It has been decided clearly that when we talk about admissibility, exhaustion of local remedy, we don't treat states, interstate, as individuals, because individuals are mandated to exhaust. But unlike states, where it is ineffective, unavailable, or even unfair, or the ground is not good, you cannot go and exhaust. So in this case, why are you expecting DR Congo to exhaust local remedies before invoking the jurisdiction of this court? And finally, if you look at the languages of the European Convention, that is the European Convention is on exhaustion of local remedy, is Article 35(1). Then Inter-American Convention, exhaustion of local remedy, is on Article 46. You will see that the language is quite different from what we have under Rule 50. What we have under Rule 50, particularly if you read Rule 50, sub-Rule E, which states that the court shall ascertain the admissibility of an application filed before it, that is, are sent after exhausting local remedies. If any, there is a provision in ours which is unique. The framers of the rules had in mind that circumstances may arise where individuals may not come, but a different body may come, where exhaustion of local remedy may not be a requirement. Why didn't you address and distinguish, if there is any? Thank you, Mr. President.
Merci à vous, honorable juge Stella Anoukam. Vous avez la parole, s'il vous plaît.
Come, you have the floor.
Of local remedy. But I have two questions. The first haven't already been asked by my colleague. And that question is to read to you a communication by the Banjul Commission and the ruling and the decision thereof. That is communication 227/99, DRC, Rwanda, and Uganda. And precisely the decision of May 20, 2003, paragraph 63, where the Commission concluded, and I read, that where the respondent state committed a violation of human rights on the territory of the applicant state, and I quote, local remedies do not exist, and the question of their exhaustion does not therefore arise. We will appreciate if you can distinguish this decision from your assertions, the assertions you have made and the submission you have made earlier. And my second question, Mr. President, goes to Our Lady, the lady who made a very copious submission on Rule 50D. That is, and I'll read, applications are not based exclusively on news disseminated through the mass media. And I wonder if you have looked at the claim by the applicant thoroughly. I have bothered to do so, and I found out that there are about 75 annexures. Will it be right to conclude that those annexures, the entire 75 annexures, all emanate from the media? And also bearing in mind that that requirement is that they are not based exclusively. We want you to address us on that. I think those would be the questions I have, Mr. President. Thank you.
Merci, Juge Anouka. Mon honorable Juge Chafika Ben-Saoula, vous avez la parole.
Justice Chafika. Thank you, Mr. President. I have two questions to the Respondent State. You considered that you linked your submissions to inadmissibility. You linked the abuse of process to inadmissibility, and I want you to explain how this link makes it inadmissible. And secondly, how you were able to say that all the evidence brought is from the mass media and therefore there's no evidence. I want you to just explain this. If what is contained in the document, for example, paragraph 92, when we make reference to the mediators, communique that was made, all those, are they from the media source or do they emanate from a reliable source? Thank you. The court will now pose questions to the applicant state. Duncan, do you have any questions for the applicant state?
To access those local remedies within the territory of the respondent state. If you did, how? And what were the results? That's if at all you did. Two, just on the face of the pleadings, save for those matters which the respondents have pointed out that they are based on news disseminated through the mass media. On the face of the pleadings, can you briefly just point out any other source of your claim, any other source, if any? I'm asking this question to help you in mind with the submission that was made by Council Aboji. And the last question is the same question I've asked the respondents. What is your comment on Rule 64, Sub-Rule 2, specifically? What is your comment on Rule 64, Sub-Rule 2? Thank you, Mr. President.
Merci, honorable juge Dankran. Honorable juge Dominique Adje.
Thank you, Mr. President. I will ask you only one question, and it is on legal issue. You address us on lease alibi pendants, and under the premise that there is a matter pending before the African Court and another one pending before the European Court, the East African Court of Justice. And if you look at our Rule 50, Sub-Rule G, it doesn't talk about when two cases are pending, but you spent much time on lease alibi pendants. So we were expecting you to address us on, if assuming one of them has been settled, then you talk about, you talk about res judicata. That is what the rule itself requires, and not lease alibi pendants. So why do you spend much time and not draw our attention to lease to res judicata under Rule 51G? Thank you, Mr. President.
Merci à vous. Honorable juge Anoukam.
Merci, Mr. President. Just still on this issue of Rule 50G regarding the applicants. Agreed, you were able to convince us that we do not have the concurrent jurisdiction with the East African Court of Justice. But in your presentation, you tried to explain that even when there is a pending application before the East African Court of Justice, what is important to note is that the parties are not the same, the subjects are not the same, and they do not have identical facts. And then my question is, in what name is the application before the East African Court of Justice? Are the parties same or are they not same? And moreover, what level is the application as at today? What stage is it as at today? Because your colleague, the Respondent State, had raised the issue of having a stay of proceeding. Would like to know what stage it is today. Thank you.
Merci, Monsieur le Président. Je vais rester un peu dans la question.
Still, in line with my colleague Stella's question, I would like to ask something. In the file, we refer to two decisions. One is the African Court, another one. With the permission of the President, I would like to have the copy of this application, before the East African Court, so that I have all the details on the merits and what is required and so on and so forth. We really absolutely need this document. We cannot refer to what you are going to say. We need to have the application to be sure that these are not the same applications, not the same parties, and so on and so forth. I have another question to ask to the applicant. You talked about a continuous violation when we were talking about the admissibility. Could you relate both? Are the continuous violation part of inadmissibility? Why have you related both issues? How continuous violation relates to the internal remedies? Thank you, Mr. President. Justices, for your questions. For you to prepare your answers, which will be submitted to the court. Regarding to the pleadings and the documents requested by the court, you have a deadline of 8 days from today till next Thursday to send them to the court. You have the floor, Respondent State.
Maître, il aurait été bien que vous nous disiez.
We'd like to know exactly what you need, as long as you think that the time limit is not enough, that is to say 15 minutes. What is your proposal? How long do you need to provide your answers, please? Give you 30 minutes for preparation. In the meantime, the session is adjourned. We will reconvene in 30 minutes. Thank you.
Yes, John. Good afternoon. Testing. Good afternoon. Microphone test. Microphone test 1. Check here. Yes. Yes, 1, 2, 1, 2, 1, 2. Microphone test 1.
Jack.
Yes, iko sawa? Unasikia chochote? Uko sawa hapo? Uko sawa?
Ladies and gentlemen, that concludes the ceremony. The families, members of the MAC, foreign dignitaries, members of the Military Command Council, and Major Generals are reminded of refreshments at Hangar Number 5 and VIP movements. I repeat, the families, members of the MAC, foreign dignitaries, members of the Military Command Council, and Major Generals are reminded of refreshments at Hangar Number 5 and VIP movements. Ladies and gentlemen, the memorial service is scheduled to proceed at 7:30. I repeat, the memorial service is scheduled to commence at 7:30. Thank you.
There's the hole here. Try to. Push that one. That one. Let's go. Push that one. Hey, wait. Go down.